So a classic example of a clash between a landlord and tenant is when the landlord is looking to construct new units at a retail park or a shopping centre, for example. The landlord is always going to maximise its profits, and everyone may be on board with this, as it will probably increase footfall for all occupants of the retail park or shopping centre. However, a tenant may negatively view it if it physically interferes with its own tenancy, or if it reduces the number of car parking spaces, its visibility, its signage, or just generally affects its trade. The crux of all this is that when you're looking at a lease, it'll have rights that are for the benefit of the tenant. Classic one is the tenant's right to quiet enjoyment, and there may be rights in there about the landlord's right to develop. Neither of those provisions trump each other. In fact, they actually have to be read together as one. The intentions of the landlord matter. If the landlord is looking to maximise profits here by doing construction or development, it is going to have a higher standard of reasonableness in how it treats the tenant, rather than just simply carrying out necessary repair works where there's a much lower threshold. So it's just, again, something to bear in mind that a landlord, if it's trying to construct new units for maximising profits, that it does act more reasonably towards the existing tenants. The landlord, from the beginning of this process, should act in a complete transparent manner. Approach the tenant from the beginning, setting out what exactly the works are going to entail, when they're going to be noisy times, when are there going to be vibrations or dust. And this actually is needed even prior to a planning application. So you need to agree your work schedule with the tenant prior to even getting in your documentation to the council. You need to have regular meetings with the tenant, setting out what's going on with the works, how they're progressing, and so forth. You should expressly instruct your contractors to have regard to the tenant, its business, its trade. You also need to look at maybe appointing a tenant liaison officer, which is a good line of communication as to what's going on. You should look at alternatives to scaffolding rather than the wraparound kind, so you're ensuring that the premises looks open for trade. Also, if there's going to be interruptions to the services, that you let them know that if there's going to be cut in water, electricity, whatever it may be, that's indicated in advance. So these are some of the practical issues. Each of them depend on their own circumstances, but you'll never regret acting reasonably as a landlord.